Okay, so shall we just go ahead and start? All right. I want to welcome everyone. Thank you so much for coming. And today we're going to learn more about our lawsuit challenging Fresno County's revision of the general plan. And we're lucky today to have with us Michelle Black, who's a partner in Karstens, Black and Mintier. Dan O'Connell, the Policy and Research Director of the Central Valley Partnership, and Radley Reep, our league expert regarding land use planning and the Fresno County General Plan. So yes, as Kay mentioned, the meeting's going to be recorded for those who aren't able to attend. And
so you got on light of filling at the same time.
Yeah. So yeah. Periodically through the discussion, we'll stop for questions. If you feel comfortable and you want to use the chat, feel free to do that as well. And we'll kind of monitor that to see if there are any questions pop up there. So I think now it's my pleasure to turn things over to Michelle.
Just before you do that, please mute yourselves unless you're speaking. I'm hearing some background noise. Thank you.
All right. Good evening, everyone. And I have to click the OK to being recorded. Okay, done. Thanks everyone for being here. My name is Michelle Black. I'm a partner at Karstens, Black and Mintier. I know a lot of you know Doug Karstens, and I've been working with him now for, oh my goodness, I think I'm now at 16 years of CEQA litigation with the firm. And we do pretty much exclusively CEQA litigation, also some Coastal Act and California Endangered Species Act, and things that go along generally with CEQA litigation. But yeah, our lives are land use planning and environmental impacts. And we work with exclusively CEQA petitioners. So groups like the League, Sierra Club, NRDC, and local community groups. Every once in a while, it's a city that's trying to enforce CEQA, but we do not defend against CEQA lawsuits. We only work on the side of trying to enforce CEQA. Okay, so lawsuit. So we filed this lawsuit, the League, the Sierra Club, and the Central Valley Partnership on March 21st. Well, actually, I think we filed the 20th, but they stamped it on March 21st. And we were challenging the county's adoption of the general plan. And Rad, did you want to go through any of the basics on that, or did you want me to do the who and when there?
You're muted, Rad.
You told me to mute myself. Sorry about that. Yes. Okay. Well, you explained who and when the lawsuit was filed. So I'll take over for the question of why. And so I'd like to actually start with you first, Michelle. If you could explain just in a couple of words why your firm feels that CEQA litigation is so important.
So, I mean, I think the main thing here for us is that the general plan is the constitution for development under state planning and zoning law. And so all decisions that get made in unincorporated county land have to comply with the general plan, or at least they're supposed to. And so when we're dealing with kind of what is a place going to look like in the future, the general plan is where you start with that. So if you're trying to fight urban sprawl, which is something that our firm actually really cares about through smart land use planning. Sprawl gobbles up our open space, our farmland, our last remaining wetlands and grasslands. It leads to habitat and species loss, longer commutes. The increased vehicle miles traveled lead to more air pollution and climate change effects. And we all know how bad the air quality is in the valley. Where I went to school, you weren't cool until you got your inhaler in PE, and it took me many years to realize that was not okay. And then I looked at the forecast, and your 10-day forecast is scary. I saw, but at least my phone is showing 4 days in a row of 112 next week, and It's not July yet. I mean, it will be by the time we get there, but it's not yet. And so, those are things that as a firm, we really care about, helping, air quality, trying to reduce the worst impacts of climate change. And so something like a general plan is, the place to defeat, some of these issues from an overarching high level perspective.
Okay, great. Thank you. And so, Dan, if you could give us oh, by the way, I don't know if we introduced Diana Durbin or not, did we?
Diana Durban.
Durham?
Our,
Wait, no, wait. I
Susan.
got Susan. I got my people mixed up here. Okay, is Susan on the call?
no,
Susan's here.
Oh, okay, all right. Sorry about that, Diana. Okay, I would say, okay, so Daniel, could you give us an idea from your perspective of why the Sierra Club and the Central Valley Partnership find this suit very important to them?
Well, first of all, I just want to say what an honor it is to be with the League of Women Voters from Fresno. It was years ago that basically Mary Zavala mentored me. But that's not just in tactics, that's in values on why it matters. The League of Women Voters of Fresno has been the absolute lead organization in the entire southern part of the San Joaquin Valley on land use. And if you're going to be a land use advocate, you have to be pretty strategically smart. This is the ground we want to fight on, even though the results happen 20 years out. If we win this, we have reinvestment in our urban neighborhoods. That's a racial justice issue, by the way. Sprawl is a racialized issue as much as it is an ecological issue. We're divesting from the urban areas where most of the people of color live. Mary taught me everything, and I just adore her. And so I just want to give a call out as I start off. I was the first farmland conservation director at Sequoia Riverlands Trust. We were only in Tulare County, and I was asked to do the first conservation easement in the history of Kern County. And so with that, I sat down at the table with this old math professor named Gordon Knipp, who was with the Kern Cahuilla chapter. And then the developer's at the table, and it's a negotiation. The developer is pounding the table. You're extorting me. And this old professor, Sierra Club leader, says, no, we're implementing the law. And he was just so flat and dignified. And I was like, wow, implementing the law and it's going to save farmland. My job was to save farmland. And when you sue under CEQA for farmland loss, usually it's a conservation easement, an agricultural conservation easement. That is the mechanism to achieve mitigation. So I then started thinking about the Sierra Club. This is not the Tehipite chapter. This is the Kern Cahuilla chapter that one old math professor had gotten together with a lawyer from San Luis Obispo named Babak Nafisi. And this was during the housing boom of 2006. They were suing every development project and winning. In fact, the greed was so high, the developers were just signing off before the lawsuit. Just the threat of the lawsuit was bringing them to the table. I was like epiphanal, like, this is that easy? Wow, let's go do that. And I thought, let's sue on every single sprawl project there is. Let's do Stalingrad. Anyway, a lawsuit is much more difficult to bring forward than that. After I was with Sequoia Riverlands Trust, I did the first conservation easement in the history with farmers of Tulare and Kern County, and then subsequent ones in Fresno and in Kings County. So that was a regional land trust. Now they have 40,000 acres in easement. They're going really well. I started working for American Farmland Trust, where I started doing policy work. Most of it was to try to get the implementation of CEQA applied to farmland. Farmland is a natural resource. We shouldn't destroy these prime soils. It is tough going. I don't have to tell you that the developers are now it's not under the table corruption like Operation Rezone. It's just campaign contributions. And it's amazing how cheaply an elected official can get bought off here for nothing. They're destroying the integrity of our cities and our ecology here. And of course, climate change is integral to this because sprawl is raising greenhouse gas emissions. So to bring it to a little bit of a close, I then started seeing the utility of lawsuits. I brought in policy lawsuits. A lawsuit was brought, actually the threat of a lawsuit in 2014 and 2015. In the winter, December 2014, the city of Fresno, with Ashley Swearingen at the lead, 5-2 vote, passed the general plan of Fresno. That plan had 3 components that were key to land use. Mary Savala would be very happy. 1, farmland mitigation 1-to-1. 2, no sphere of influence extensions. And 3, a prioritization of infill development to greenfield at a 60-40 ratio. 1 month later, we bluffed the city of Visalia that they thought a lawsuit was coming if they didn't. And they basically, the same values were in the 2015 general plan of the city of Visalia. Since then, we've been fighting to implement those general plans. Those weren't from lawsuits. Those were votes of city councils, which was really important. So coming here to the moment we are now, about 2009, I start becoming active. I'm at a table set by the League of Women Voters. And there was a huge coalition, maybe 20 groups at the table. We were gearing up to advocate on the general plan. The economic constitution of the county of Fresno was coming forward. Yes, we're going to fight on that ground. Yes, that is vitally important to the integrity of the most important food producing region in the world needs to get smart growth, or else we're going to just develop like LA. The county obfuscated, delayed, every single tactic you can imagine was employed. And here we are now at 2024, and only 3 organizations held on for the entire time. The League of Women Voters, of course, and I'm going to just pause right now and say, Radley Reep is a hero. He works. I can't imagine what his living room looks like. It must be piles of stuff. His life is dedicated to this. So, and then the Sierra Club, which the Sierra Club, I'm the land use and conservation and agriculture and land use committee chair for the Tehipity chapter. The current Kauai chapter was always better at bringing lawsuits. Now with Gary Lasky and with Jeremy Chiklar and a few other lawyers, we have now been able to bring forward lawsuits. And hey, the Central Valley Partnership and maybe the League of Women Voters are not going to scare the other side. They should be scared of you. But the Sierra Club scares them to death. Just the name of it. And usually the Sierra Club is not a lot of people. But they know how to bring a lawsuit, and they're formidable because of their national posture and history. The 3 organizations, the Central Valley Partnership, the League of Women Voters of Fresno, and the Sierra Club Tehipity chapter, a mighty coalition. I personally don't believe in doing lawsuits alone. It leaves you vulnerable. And we have different skill sets here. I know how to implement mitigation, etc. I was not there with the Friant lawsuit. And part of this, the Sierra Club Tehipity is actively engaged in this for multiple reasons, but one of them is to defend Friant lawsuit because we sense that this is an end-around threat to that precedent-setting lawsuit. I'm enthusiastic. I'm going to stop there. We can pick it up in questions. Thank you all. And we're missing a really important debate to be here. So we know all of us are super dedicated people. I'll pass it back to Rad. Thank you again. And I'll be here for questions.
Thank you, Dan. As for the reason why the league is involved, while I was not at their board meeting when they made the decision, I'm going to make a guess that it was all about transparency. And I'm hoping that it was, because that's the league really believes that transparency is a cornerstone of a healthy democracy. And, it promotes confidence in government and enables residents to participate effectively in civic matters. So I'm hoping that that was the primary motivator. And I'll let it go at that unless Kay or Robin want to add something else.
No, there are so many things not to like about the county general plan. Transparency is a huge one, but we have all sorts of positions that have been radically defied by this plan. But I think we might as well just, unless there are questions right now from anyone, we'll move on to the specifics of our lawsuit. Does anybody have a question? Okay, the specifics of our lawsuit revolve around violations of both CEQA and state planning laws. And Michelle, why don't you go ahead and start by introducing, just briefly, what is CEQA, in case someone here, might not be terribly familiar with that acronym.
And I'll just throw in real quick that the firm has a little bit of skin in the game because of the Bryant Ranch decision and project that we worked on with the league and with Sierra Club. There was a great California Supreme Court decision we'll talk about a little more later, but it did require better disclosure, air quality impacts will affect human health. And we do want to make sure that that precedent, is brought forth in this EIR for the county general plan. And then also my family's from the Valley. And I think I spent all of 2016 hearing my dad complain about how, the northern suburbs and disinvestment in the core of Fresno has destroyed Blackstone and destroyed everything he loves. And so, I'm pretty sensitive to kind of these issues in Fresno. So the California Environmental Quality Act, for those of you who don't have to spend all day reading boilerplate legal documents, and my goodness, I hope that's most or all of you who don't have to do that. CEQA requires that a city or a county prepare an environmental impact report for any government action that may have a significant adverse effect on the environment. And a significant adverse effect on the environment is pretty broadly defined. CEQA does not prevent the county from approving the project that will have adverse environmental impacts, but it does require that anything that's going to happen be disclosed to the public and to the decision makers, that the county evaluate alternatives to those actions that will reduce or avoid those adverse impacts or those harms, and that the county incorporate all feasible mitigation to, again, avoid or lessen those harms. Now, if the county does choose to approve a project that will have cause environmental harms, as here, it's required to make a couple of findings. So it has to make a finding that it incorporated all feasible alternatives or mitigation measures to reduce or avoid those harms, that further mitigation would not be feasible. And of course, there's a legal definition for feasible, but it's more than just it would cost a little bit more. It has to actually make it so that it's not practical to go forward with the project. And then the county also has to find that the environmental harms that could not be avoided with this project are outweighed or overridden by the good that the project will do. And that's called a statement of overriding considerations, and that'll be important a little bit later. So the main purpose of CEQA is to promote better environmental decision-making. If your supervisors have all of the information about a project's harms in front of them, and they also have in front of them ways that they can, make the project better and avoid those harms, it's a lot easier to, make that project better or to reject a bad project outright. Slightly subordinate to that main purpose is that of governmental transparency, as Rad already brought up. The CEQA process is designed to be public, so that the county decision makers and the public are fully informed about a project's environmental costs before a project is voted on. And if the public doesn't like the decisions that are made with that information, they get to vote out their elected officials, or at least they're supposed to be able to. So there are various ways that a city or can violate CEQA when it has done any, and the county did do an EIR here. So they did one thing right. But these violations generally involve the failure of that EIR to disclose certain environmental impacts, to disclose the magnitude of those impacts, or the failure to actually incorporate adequate mitigation or alternatives to the project to reduce them. So specifically in this lawsuit, one of the things you'll see a lot, in part because of Bryant Ranch and in part because they did such a bad job with air quality, you'll see a lot about air quality. So in the final environmental impact report that was certified or approved by the county, they did add mitigation measures for emissions of conventional and toxic pollutants. So adding mitigation measures for air quality, that's a good thing. We like that. But because those measures were added at the final EIR, And unlike the draft EIR where there's, a long comment period where people have time to read the document, groups like us can, try to get expert commentary or experts to review, and actually, submit feedback to the county. With the final EIR, they only have to give us 10 days. Actually, they don't even have to give us 10 days. They only have to give us 3 days. And they have to give, the city 10 days. But even if they give us 10 days, that's not enough time to look at thousands of pages of responses to our comments and get those evaluated by experts and, see, do these mitigation measures actually work? And as far as we can tell, the county, when they implemented or when they incorporated these new mitigation measures, these new things that are supposed to make air quality a little bit better, they didn't evaluate whether, what the pollution levels will be with those new mitigation measures. And since they didn't put that in there, we don't know if the emissions of ozone precursors or fine particulate matter will be significant or not. And an EIR is required to say yes or no, something is or is not going to be significant. We don't know. An EIR is also supposed to required to evaluate the mitigation measures that are included so that will they work or not, or how well will they work. And this one didn't do that. So that is one of the first things that you'll see in the lawsuit. And then as mentioned before, the 2018 Bryant Ranch decision requires an agency to evaluate the project's air quality emissions and then tie those to the potential for human health impacts. So we're going to emit this many pounds of particulate matter at 10 microns, and we think it'll do this to asthma rates. And obviously that's a very, very technical analysis, and there are limitations on the modeling and what we can and can't do. But if the county doesn't do that analysis, put it in the EIR, they have to explain why. So here, they didn't do the analysis. They said it's not possible to do it. But we know that since the 2018 Bryant Ranch decision that consultants have started doing this. So, it may not be perfectly accurate, but it is possible. And so we don't think the county has what's called substantial evidence to support their decision not to do it. So we don't think they have a legal leg to stand on, more or less. So that's in here. Another thing that's in the EIR, there's a lot about vehicle miles traveled, because we now analyze traffic through VMT, because the goal is to shorten trips and not just widen roads and add new stoplights and things like the level of service traffic standard we used to use encouraged. So for their VMT analysis, we don't think they justified the average number of vehicle miles traveled that they think each person is going to do. And then in addition to that, the EIR purports to adopt mitigation measures to reduce the vehicle miles traveled. But these mitigation measures talk about encouraging or supporting different things. But one of the main rules about CEQA mitigation is mitigation measures have to be concrete and enforceable. They're not just a wish and a hope and things you would like to see happen. They have to have standards so that you can ensure that they are being implemented, and you can measure whether or not they're being implemented. We'd like to encourage doesn't really accomplish anything. So we've challenged that. Let's see. So alternatives, as I said earlier, I think the Laurel Heights case, maybe California Supreme Court case, says the core of an EIR is the alternatives analysis, because that's where you look at alternatives to a project that will reduce the things that a project may cause that are bad. So you need to analyze a couple of different alternatives. You have to do the no project alternative, so the not doing the project, and then typically something else. Well, here the EIR only compares to the no project alternative and to 2 alternatives that would propose more growth than the general plan does. And with more growth, it's kind of impossible to reduce the growth-related impacts that we're concerned with mitigating here. So we don't think the alternatives analysis serves the purpose it's required to under CEQA. And then last one I have in CEQA, before turning it over to Rad, is the statement of overriding considerations. So again, if you're going to approve a project that's going adverse impacts, and you are completely allowed to do that. You have to find that you did everything you could to mitigate those impacts. And there are certainly mitigation measures and alternatives that were not considered or that were rejected without adequate rationale. And so the statement of overriding considerations here does not. And Brad.
Okie dokie, thank you. All right, I'm going to finish up the section on our CEQA challenge, cause of action for the project, talk to you a little bit about the project description, climate change in the revision general plan, and also the general plan's theme for urban-centered growth. And I'll make this as brief as possible. Afterwards, we can have a few questions if you'd like to join in. So as far as the project description is concerned, for me, personally, this was a very important thing. If I, as a citizen, don't understand what the project is, it's very hard for me to participate. I don't know what to say, and I don't know how to respond. And so there was a problem throughout this project. Many of you know that this project took 18 years to finish from start to end. Started in 2006, ended in 2024. And during that time, the county failed to disclose whether it was actually updating the general plan or revising it. And I know that sounds like a silly question, but with an update, you have sort of a different approach community-wise to looking at the general plan. Revision is more in-house, update is more public. And the county did not ever say that it was updating its general plan actually, but it actually did that. So that's one thing. The second thing is that the county failed to initiate any dialogue with the public about what to update in the general plan. Back in 2000, they opened up the doors and said, we want a brand new general plan to help everybody. That was the 2000 general plan. Please tell us what you want. They did studies, they did interviews, they did surveys, all kinds of things to get public information. This go around, they decided to do nothing. So the public was never invited in to the process at all to initiate that groundbreaking work. Thirdly, the county maintained all through those 18 years that the general plan was not undergoing a major change. They made that clear at every meeting that they do open with that idea. But behind closed doors, they were making significant changes in-house. That is to say, the Board of Supervisors and staff. And so the league did a study, and in May 2023, the league figured out that the county was proposing to delete or significantly revise 82 of 121 programs in the general plan. That's 68% of them. And as far as policies, to significantly change or to remove 174 of its 604 policies. That's 29%. And the draft also added 58 new programs and 125 new policies. Now, to my way of thinking, that is not just a revision. That's an update of the general plan, and the public should have been involved all the way in making those kinds of decisions. Number four, the county took the position that the old EIR done in 2000 was gone, and they would replace it by a new one in 2024, even though they said, actually, we're still working under the 2000 general plan, just revised. But by having a brand new EIR, they were able to avoid evaluating why they were deleting a lot of mitigation measures that worked in 2000. There were actually 300 environmental mitigation measures adopted in 2000, all of which were dismissed when the county started its new EIR. They never went back and looked at those old mitigation measures to see which ones should be carried forward or not. And so that's extremely frustrating to me. And lastly, the county put out a publication every year called an annual progress report that was supposed to detail how well the county was able to implement its general plan. And the truth was it was failing badly to do that job. But its reports all said it was doing well. So they were incomplete reports and misleading. And so the public really had no data to work with to really judge what needed to be changed to the general plan. So that's the problem with an inadequate project description. As far as a climate action plan, As far as I know, the state does not require that a county have a climate action plan, but CEQA does see the importance of that kind of analysis, so there should be something there. As a result, in 2012, the county added a climate action policy and program to the draft revision of general plan for the first time. 2012, there it was. We all cheered and went, yes. It was both a program and a policy. But then the county had second thoughts on that. And the first thing it did was it changed all the shalls in that program and policy to shoulds. And then by 2017, they simply deleted the policies in the program. They disappeared entirely. Everybody raged to stink, of course. And in 2023, they put them back a little differently. But unfortunately, when they came back, they were very odd. Two policies. One said that the county would begin working on a climate action plan within 2 years of revising the plan, which seemed kind of odd. The other was that they would begin doing it once funding was available. And of course, we know the county doesn't have any money. And so we looked at those and thought that's about as ineffective as it gets as far as getting anything done at all. Fortunately, the county did put a little bit of information in its background report and in the EIR on climate change, but it's scattered, confusing, and it's really hard to interpret what it is. So like they took some information, just threw it in there to make it look good, but it doesn't do anything for me. And then lastly here on urban-centered growth and ag land protection, this is a real biggie. The current general plan from 2000 has a theme called urban-centered growth, which means all the new growth supposedly goes into a city or into an urban community of some kind. In fact, I'll read to you what the theme looked like in 2000 and what it sounds like rather in 2024. In 2000, it read, the general plan promotes compact growth by directing most new urban development to incorporated cities and existing urban communities that already have the infrastructure to accommodate such growth. That already have the infrastructure is the important thing. That's what really stopped urban sprawl in the county. They're replacing that with that already have the infrastructure with where public facilities and infrastructure are available or can be provided to accommodate such growth, which means they don't have to already have it, they can put it in, which is a huge change in thinking. And the policy that went with that, I'll give you a number if you're interested, policy LUA.1. It said in 2000, urban development can be expanded to areas of the county where public facilities and infrastructure are available. And in 2024, they added the words and or planned for, which means if they can do the planning for it, they can put it just about anywhere. And the difficulty here is that the EIR did not seriously look at these major changes to find out what does that really mean for the county if the county actually follows these policies. As far as ag land is concerned, the county decided to eliminate or modify 30 policies related to ag land. None of them are good, and I'll give you 2 examples of each. So for a program, they eliminated a program requiring the county to conduct an evaluation to determine the parcel size that's necessary for sustained agricultural activity in the county. Would have been great information. And they also eliminated a program requiring the county to periodically review agricultural land preservation programs to assess their effectiveness in furthering the county's agricultural goals and policies. That's now gone as well, including about 10 others, which I don't have time to explain to you right now, just as serious. As far as policies, they eliminated these 2 policies, they changed these 2 policies. It's all about where industrial development goes in the county. So in 2000, it reads, the county shall encourage the location of new industry within cities and unincorporated communities. But now in 2024, it reads, the county shall encourage the location of new and expanding industry within Fresno County. No longer to the cities, just anywhere, basically. And another one, the second one is another policy, the county shall encourage processing facilities to locate in industrial parks under city jurisdiction or within existing unincorporated communities. So you can imagine where theirs would go. But now the policy in 2024 reads, The county shall encourage processing facilities to locate in industrial parks in areas with adequate infrastructure, not within the cities. That's now gone. And so, yeah, as you know, they're trying to put in a brand new area in an ag area for industrial expansion. So you can see how this is all set up this way. So those are the items that Michelle and I have explained to you, or giving you an idea of what's in the CEQA part of the lawsuit. We can take time out for a few questions if anybody has any or comments. We were that clear? I don't believe that.
Dad, can you talk just briefly about the addition to the general plan of the study area that involves a great deal of unincorporated county land for development?
Right. The one is along the Golden State Corridor, south of Fresno along 99 there. That's a county project where they want, I think it's about 3,000 acres of ag land to be put into industrial development. The other one is a 7,000 acre area along the Kings River. And by the way, am I getting some feedback, or do I sound okay? Because I can hear feedback coming back to me.
You're fine.
I think Janet needs to mute herself.
Oh, okay.
Okay, great. All righty. So there's the 7,000 acres near the Kings River where they would like to put in some sort of an educational facility with housing and everything else out there. That was brought by a developer or two, and the county couldn't say no. And so it said, okay, we'll put it in as a study area. We're not endorsing it, but it's just in there. And that was the county's way of getting that project started. Okie dokie. Any other questions? Then the second part of the lawsuit is one where we are complaining and seeking a remedy where the county failed to update its general plan to meet state laws. And there are 4 laws we're going to talk about really quickly. Michelle will talk about SB 244, which has a lot to do with disadvantaged communities. AB 1000, which requires the county to put in policies and programs for environmental justice. I'll talk about AB 170, which is an air quality policy regulation, and SB 379, which is all about climate resiliency. So, Michelle, SB 244.
Do these pretty quickly. So both SB 244 and AB 1000 have to do with environmental justice, which we are finally starting to recognize in state law, even if the rules aren't as mandatory as I would like them to be. So SB 244, about 11 years ago, the legislature mandated that when the county update its land use element, it needs to identify disadvantaged unincorporated communities, because it's pretty common to have communities outside of city limits that just kind of get forgotten. You put all of the industrial there and no one's really able to complain. And so you just keep doing it. So this legislation requires that the general plan land use element update identify those communities, their service deficiencies, funding sources or strategies to remedy those deficiencies. We pointed this out in our draft EIR comments, and there were some changes made to the final EIR that did improve this. We do think they still could have done a better job, but it looks like the county maybe kind of tried on this. So yay, but not good enough. So we did put that in the lawsuit. AB 1000 was enacted a couple of years later, 2016, requires cities and counties to add an environmental justice element when they update their general plan. The county did try to add an environmental justice element that recognizes the disproportionate pollution burdens that certain communities experience and the health risks that go along with that. Again, communities more likely to be located next to freeways, industrial sources of pollution, ag chemicals, water pollution from longstanding ag practices. The county general plan does recognize those burdens in those communities to some extent, but And it does include lofty goals for, improvements and goals, but these are more kind of wishy-washy statements of things we would like to achieve. They are not, it's more like I'd say they're not even shoulds. Where Rad said some of the shalls became shoulds. Here, I'm not even sure we're quite to should. And we would like those to be stronger. So we've put that in here.
Okay, great. As far as AB 170 is concerned, this one absolutely amazes me. This is a very, very old bill. I don't know when it was done, but it goes back more than a decade or more than two, maybe. And what it did was the state legislature told the counties within the San Joaquin Valley Air Pollution Control District, you have to put together some comprehensive goals, policies, and implementation strategies to improve air quality. That makes sense, right? Well, as hard as this is to believe, the county never did it. They just thought, well, I guess the Air Pollution Control District is taking care of things, but they took no responsibility themselves for these things. And we know that the county didn't because we have copies of the contracts with the consultant for this project where the contract says, consultant, we have a problem with AB 170. You've got to go in and fix it. So there's no question that the county is aware of the problem. The difficulty here is that, well, I would say that when I try to search the new general plan for these implementation strategies and policies, I can't find them. Now, the county's going to claim that they're buried in there somewhere, I'm sure. I don't know where. But to tell you the truth, I can't see them. And it would have been nice if the county had said, in order to comply with AB 170, we have these policies and programs, but we don't have that. And so it's up to us and the courts to kind of figure out if there's anything there or not. But I would say there's not. As far as SB 379 is concerned, that's the climate resiliency planning that's required. Well, I mentioned before that the state doesn't require a climate action plan where you reduce greenhouse gases. It does require planning to deal with climate change. All right, that's definitely in the law. And the interesting thing about this is the county's known about it for a long time. And back in 2019, they tried to incorporate these strategies to deal with climate change in what's called its local hazard mitigation plan. And the county planned then to put that local hazard mitigation plan into the general plan, and that way they'd get it all done. But come the day when that was supposed to happen, it turns out they tried to put the local hazard mitigation plan into the general plan without doing a general plan amendment. I know that sounds totally off the wall and crazy, but you have to understand what county we're in. So I'm patting myself on the back. So I go down to the board of supervisors and I say, excuse me, but I think if you're going to amend the general plan, you actually have to have a general plan amendment. And county council looked at the 5 board members and said, yeah, he's right. We can't do this. And so they never did it. So now what are they going to do? Because it has to be in the general plan. So they threw a whole bunch of stuff into the EIR, which is not exactly in the general plan, on mitigating climate change. So it's not very useful there at all. They put some information in the background report, but they don't really specify, the county doesn't really specify that this is how we're meeting the requirements to SB 379. Again, it's up to us and the courts to try to figure out if there's anything there. So I would say generally, regarding to the county's compliance with state law, with its revision plan, it's poor, missing, just an embarrassment, really. I don't know why the county would want to do that crappy of a job unless it has no choice. Maybe it doesn't have the manpower, or maybe the people at the top are saying, no, I have no idea. But they've opened themselves up to a lawsuit, which of course we've filed. Does anybody have any questions for Michelle or I, or any comments regarding these 4 laws?
I hate to occupy all the question time, but what are we asking for in this lawsuit? You might want to explain that. What do we want the county to do about all these violations?
Mhm.
So in a CEQA lawsuit, all we can really ask for is that they fix the environmental impact report. So if on the CEQA side of things, we got everything that we wanted, it would be the requirement basically that the county do it again. So that could mean that the county revisits the general plan itself, or it could just mean that they, admit that some of these environmental impacts will be significant and adverse, and they haven't mitigated them, which should require that they actually mitigate them, but might result in them, finding justifications for why things aren't feasible. Under the planning and zoning laws, if we went on those, then the county should be required to actually comply with those laws. We can't dictate how they do it. The court can't dictate how they do it. But there is if a writ is issued or an order that commands the county to comply, there would be a kind of return to writ process in the court where the county would have to demonstrate that they've complied with the writ before that writ would be discharged. So we don't know what it would look like, but there'd be some kind of a do-over.
Right, and with the do-over usually comes a requirement that the county set aside the project, which means that the general plan revisions would not go into effect until whatever was straightened out had to be straightened out. And I'd like to mention one little aspect of our lawsuit, which is the baby I'm concerned with and interested in. And I'm not sure if anybody else is or not, but we have a major problem here with public engagement in this particular project. And for me, the question is this: if the public is given false information about the project, its project description and so on, and if the public is not invited in, even though they beg to be invited into the process and they're left out of the process, then if the process is that corrupted from start to finish, is the project viable or not? And it would seem to me that I would love to have a decision by the court that you can't go that far in mistreating the public and come to the conclusion that nonetheless the project turned out well. I would like them to say that it's fatally flawed just because the process was so bad. And if that we would have went on that, then they'd have to go back and do the process over again, which seems to me to be the right thing to do. And Michelle probably is thinking that's not going to happen, but nonetheless, that's something I would like to see.
It's what we always want. I mean, actually, CEQA is more of a process statute than anything. Like, it's the rules, the way that the standard of review works. When you have did they follow the procedural requirement issue, it's the judges get to say yes or no. Most other aspects of CEQA, was the air quality analysis complete enough? A lot of those questions, the county gets to rely on what's called substantial evidence, which means that, if the county has evidence to support their position, even if it's a total lie sometimes, but, that lie has an expert's name on it, they win. So a lot of times a process hook is the better way to get a good result. We'll see what we get here. So we filed March 21st. Right now, the county is preparing the administrative record in this matter, and the administrative record, that's the evidence that we will cite in our briefs when we get to that stage. And for a case like this, it really just consists of everything that's in the county's files. So it's the draft environmental impact report, the final environmental impact report, our comments of other people, public testimony, the expert reports supporting our comments in the county's reports, probably emails between consultants in the county, and things like that. So it's not, discovery like in other civil litigation. There shouldn't be subpoenas or depositions or anything, but it can take a while to get these documents together. And then also, I'm going to guess the county doesn't want to go to court tomorrow, so they're probably not preparing this record as quickly as they possibly can. We've stipulated right now to have the record done by mid-September. It would not surprise me if the county stipulates to take a little bit more time. But once that record is together, we will set a briefing and hearing schedule depending on the court's availability, and we will start briefing. We do have a status conference or a case management conference with the court on July 12th. But because that is a good 8 weeks before the current expected completion of the administrative record. I think that is going to be about 90 seconds long, and the court will say what's happening. We will say the county's working on the record, and the court will say, okay, I'm going to set a date for you to come back and tell me where things are. And then we'll see if we need to agree on, briefing and hearing schedules. So I think that'll be a kind of a pretty quick pro forma thing, and we won't know a whole lot more for a few more months.
Yeah, for most people, I think the amount of time that this takes is mind-numbing. We filed in March, and it may even take till 2025 to get the record put together. And then after that, there's the briefing that needs to be done, the court decision, and so on. And so we're talking about well into 2025 before a lower court decision will come through. That's really sad, but that's the way these things work.
On the plus side, I am not putting together that record, so no one is paying me in the meantime while nothing is happening.
Okay, any other questions regarding any aspect of the lawsuit? Yeah,
I want to
Nancy.
make a comment. I am in no way saying that this is legit, but the county is going to recall that they had those community meetings, workshops on the general plan, right? Brad?
Yes.
Talk about
Yes.
what that consisted of, please.
Yes, right. The county had 15 or more what they called workshops on the general plan. And that all sounds good, especially to a court judge who says, wow, they're doing their due diligence to bring in the public. However, the way they went is the county would stand up in front of the audience and say, we're making minor changes to the general plan. Don't worry about it. Nothing's going to happen, really. And then they would say, do you have any questions? There was a small presentation usually, but nothing, they didn't explain, these are the policies we're changing, these are the programs we're changing, and so on. That never happened. And they were usually conducted in small communities throughout the county where the public who went didn't understand general plans in the first place. And so what they usually turned into were complaint sessions by the local people who live there saying, we have too much pollution in our neighborhood, and we have too many potholes, and the traffic is horrible, and where our water is undrinkable, which really wasn't the purpose of these workshops. The workshop is supposed to be a time where the public can engage with the with county people to understand what's going on. I think the worst one I went to was in Kalinga, when the planning person from the county stood up and said, welcome. We're not going to answer any questions today. We will hear what you have to say, but if you ask us a question, we're not going to give you an answer. That was a fun one. That one I had to, in fact, I even took my own tape recorder to tape that one because it was so unbelievable. So when I spoke, I would have to say, well, if I were to ask a question, if you were to answer it, this is what it would be. So the workshops were an embarrassment, really. They didn't do anything for the public at all, although they may look good to a court judge who is looking at all the long list of community meetings that were held. And by the way, at none of those meetings did they ever ask, what is it that you want us to change in the general plan? No, they said, this is the general plan change we're making. Do you have any comments?
I know that the city is also suing the county over the general plan. Do you know anything about the status of that suit?
So I
Michelle,
do know
have to
that
defer to
their
you.
case management conference is a week after ours. And normally by now, since we told the courts that both of these cases existed, which will be using the same administrative record and are against the same entity over the same project. Normally by now, the courts would have put us in the same courtroom so that we'd be on the same schedule. And that has not happened yet. I have no idea why. So it's some point in July, I think the judges will go, oh gosh, we have two of these, and one of us will get moved. But so far, all I know is that the record was extended in both cases, and the city has alleged the same causes that we have under CEQA for air quality. They also talk a lot more about urban sprawl and ag land, farmland conversion. There's a fair amount on groundwater overdraft, growth-inducing impacts, and not designating housing sites in the urban core. So a lot of the same concerns worded a little bit differently, but we'll see.
I sense that the city's lawsuit was complementary to a lot of ours. We went deep into air quality and to some equity issues. Some of the issues I care most about, I deferred here to the lawyers and their expertise, but the city did pick up the ag land, the infill. These are key. Remember, this is an economic constitution. So the city was and is defending its interests. So kudos to the city for doing this. That big industrial, 3,000 acres right next to the city down south, that is not beneficial to the city of Fresno. And there's a lot of problems here. So the city did go ahead and defend their interests, and good luck to them as well.
There's been a lot of reference to the Bryant Ranch suit. For those of our members who don't know anything about that, just briefly, could you just describe what the status of that suit is and how it got brought into this one? You're muted, Michelle.
And then of course, the window that tells you you're muted blocks the mute. You can't click it, fix it. I will go as brief as I can, but we're what, 20 years and bounced around every court. So I will hit the highlights as quickly as I can. So the Bryant Ranch development, 2,500 homes, supposed to be for people ages 55 and up by Millerton Lake, on 942 acres, was approved in 2011. The Sierra Club, the League, Revive the San Joaquin, and the City of Fresno challenged the EIR on a number of grounds, including water supply, air quality and health risk impacts, in separate lawsuits. In December of 2012, we lost. Fresno Superior Court ruled against us. The League and Sierra Club appealed, and the Court of Appeal reversed, finding in favor on air quality in May of 2014. Went up to the California Supreme Court after that. And in December of 2018, we got a what I would call a landmark ruling, finding the Bryant Ranch EIR inadequate with regard to its disclosures on air quality impacts, and specifically on tying those air quality impacts to impacts on human health. So significance of that, all CEQA practitioners think this is a really big deal. It shows up in this lawsuit. So while it was always required for an EIR to disclose the types and amounts of pollution, air pollution generated, have to actually tie that to human health. And again, if there isn't a good way to do that, because these do require complicated, sophisticated computer models, you have to explain why, and explain what you can to the best of your ability. And then since this 2018 decision, several consulting firms have come up with different ways to do this type of analysis. And so while some cities and counties are still claiming it's impossible, we are overall seeing, marked improvement in EIRs and their discussions of air quality impacts and impacts on human health. And so when these risks go public, which is, part of the transparency required in an EIR, you do see better project mitigation, better project siting, required technological innovation to reduce impacts. I think we are seeing, some really big improvements statewide in how projects approach human health. So yay. And then another big ruling, a little further into the legal weeds. This case had a really important holding regarding the standard of review that CEQA petitioners have to rely on. So some CEQA issues are substantial evidence issues. So issues where, as I said earlier, if a city or county has anything to support them, even if it's, bad evidence, they win. Oh, well, we did an analysis of groundwater and we dipped a stick this way, and this expert says we can do it, and we'll come in and we're like, well, we had an expert who measured the amount of water in the basin, and it's not enough. Oh, no, we choose our expert. So substantial evidence, it's really tough. I don't want to say substantial evidence issues are unwinnable, but it's really hard. Other issues are reviewed de novo, subject to the court's independent judgment. And so in the 2018 Friant Ranch opinion, the Supreme Court held that any claims that an EIR lacks analysis of an issue, so for us, analysis of health risks as related to the air quality risks, or amidst the magnitude of an impact. So how, is this a small impact, or is it a bad thing? Is it really bad? Those are mixed questions of law and fact, and so they are subject to the court's de novo review. And so that means a lot more CEQA claims are winnable overall. Not a slam dunk, but we have a fighting chance. So this case gets cited in every published CEQA decision for the standard of review. So 5 years have passed since that 2018 Supreme Court decision. In early 2019, the case was punted back to the trial court to implement the decision of the Supreme Court. In March of 2019, the trial court issued a writ, an order commanding the county to undo all of its Friant Ranch approvals, all of the entitles, decertify the entire EIR, start over. You'd think we were done, but of course not. So Friant Ranch immediately contested this order. They argued, it wasn't necessary for the county to vacate all of the approvals, or you didn't have to get rid of the entire EIR. There were only teeny tiny little pieces of the air quality analysis that were bad. Let's save the rest. So in August of 2019, the trial court issued its tentative ruling, finding that the required findings to keep things in place couldn't be made. They sided with our argument completely. No, we're going to make them decertify the whole thing, pull back all the approvals. So got in the car, drove north on 99 toward the hearing. But because there had been a delay in the scheduling the hearing date, Friant was going to have to appeal the decision in our favor before the hearing was actually held the next day, which is just crazy that that's the rule, but okay. So knowing that the writing was on the wall, the court was going to rule in our favor. Friant Ranch appealed while I was on 99. But they were nice about it, and they did let us know. So I flipped a U-turn in Pixley and was back in time for daycare pickup. So that put us back in the Court of Appeal 9 months after we had just left the Court of Appeal, and just in time for COVID. So at the end of 2020, the Court of Appeal upheld the trial court's decision to require full decertification of the environmental impact report for the Friant Ranch project, full rescission of all Friant Ranch approvals. So February 2021, finally, the court decertified the EIR, rescinded all approvals. But at the same time, a supervisor very explicitly stated that the county would be reapproving the project once the CEQA compliance was fixed. I would just not consider that to be a best legal practice, but I am not county counsel. So that brings us to where we are here. But yes, as Rad knows, I have saved every version of every media that quoted that supervisor. I'm just like, they prejudged the outcome. So that brings us here. The county released a partially revised and recirculated EIR in February of 2023. They've tried to limit their EIR to just new analysis of the air quality, well, a tiny subset of air quality issues. And then they did put out some new information on water, but said that we can't comment on that and we can't comment on anything else. They're only accepting comments on this tiny little subset of air quality issues. So we think that is not something they're allowed to do. The court required them to decertify and redo everything, and they don't have a certified EIR. And if you don't have a certified EIR, you can't use the portions of CEQA that let you rely on the old EIR. So maybe you should start over. Also, it has been 13 years since the last EIR that was found inadequate, and a whole lot has changed with air quality, with groundwater, with global warming, with everything under the sun, or I guess global weirding at this point, because I've had 52 inches of rain in my house in the last 2 years. And so we do think that there's a lot more that is required to be done, but that saga continues. We submitted, and lots of groups submitted public comments on the air quality issues, on the issues that we think that they also need to do, on the fact that we don't think they're complying with what the court told them to do. And we are awaiting a final EIR, and we'll respond once we know what we're responding to. But in the meantime, we have a really good decision on the requirement that agencies look at human health risks and air quality in real detail and make some real disclosures to the public. in an area that really needs it because, man, our asthma rates are terrible.
Brad, if you're talking, you're on mute.
I'm sorry. I'm
Yeah,
assuming there are no more questions, and we've reached the end of our allotted time. Thank you so much for all of your attending, and it was so important to us to let you know exactly what we're up to with respect to suing the county once again. Thank you, Michelle, for being here, and Dan for being here, and Rad for all the work that you've done on this issue
Right.
over the years.
Right. Kay, can I just, sorry about this, but just interject one last little thing on Friant Ranch? I was going to
Sure.
speak, but I was muted there. Sorry by mistake.
Sure.
I was going to say, I don't know why the county has waited so long to release the final EIR. It could be that it's prepared and it's just waiting in the wings for something. Or it could be that they realize there's really big problems with it since they limited us so much on what we could comment on, that they're kind of in trouble and don't know how to get out of that problem. But there are a few changes in the general plan which may help projects like Friant Ranch move forward. So if Friant Ranch has to move forward under the old general plan, we have policies about urban-centered development, which Friant Ranch is not. And we also have the requirement for regional planning in that area before a big project like Friant Ranch comes through. But the changes in the general plan have allowed urban projects to be put wherever facilities can be provided. And they've also removed the requirement for any regional planning in that area. So that sort of opens the door for projects like Friant Ranch to move forward. So I can't imagine that the revisions that have been made would be, I think they'd be welcomed by Friant Ranch and other developers. And so maybe people are waiting to see what's going to happen on this general plan. I have no idea.
Or maybe interest rates are high and that's on the developers. You never know.
Yeah, we just never know what the story is.
Or they're waiting for November 5th.
Oh, well, we won once before. Thank you for that, Michelle, you and your law firm, and to the Sierra Club for joining us on that suit. And let's hope maybe this one doesn't drag on for quite so many years. But thanks all of you for attending. And next month, we're going to have a member meeting about water. In the middle of much heat. Water sounds good. Good night, everybody.
Okay, good night.
Everyone, thank you so much.